we have a minister who has tabled many bills, but often I feel that these bills are in reaction to the headlines.
It's my pleasure to speak on Bill C-54, the Not Criminally Responsible Act. The government introduced this bill because we want to ensure that public safety and the needs of victims receive the appropriate emphasis in the criminal code mental disorder regime. As you may know, the mental disorder regime is the part of the criminal code that deals with accused persons who are found unfit to stand trial or not criminally responsible on account of mental disorder. The Not Criminally Responsible Reform Act does not apply to all individuals in the criminal justice system who have a mental illness. Rather, this bill focuses strictly on those who come within the purview of the Criminal Code's mental disorder regime and the corresponding provisions of the National Defense Act that deal with mentally disordered accused who are tried by a court. The mental disorder regime in both statutes applies only to individuals who have been found unfit to stand trial or not criminally responsible on account of mental disorder. Individuals who have a mental illness but have not been found unfit or not criminally responsible are dealt with in the traditional criminal justice. Mr. Speaker, to better understand exactly who is captured by this bill, it's important to understand the concepts of unfit to stand trial and not criminally responsible. Unfit to stand trial and not criminally responsible are two distinct concepts in criminal law. The question of whether or not an accused is fit to stand trial can arise at any stage of the proceedings before a verdict is rendered. If an accused has been charged with a criminal offense but is unable, due to a mental disorder, to understand the nature or possible consequences of the trial proceedings or to communicate with a lawyer, then the court will make an order declaring the accused to be unfit to stand trial. The question of whether or not an accused is criminally responsible for the offense charged focuses on the mental state of the accused at the time of the alleged offense. An accused may be found not criminally responsible due to a mental disorder if at the time of the alleged offense they lacked the capacity to either appreciate what they did or to know that it was wrong. The finding of not criminally responsible is neither a conviction nor an acquittal. It is a special verdict. Since a person found not criminally responsible is not convicted, the person is not punished or sentenced. Instead, the person is referred to the provincially established tribunal known as the Review Board, which is tasked with making decisions about the monitoring and supervision of mentally disordered accused persons. Now, C-54, the bill you have before you, has three main components. First, it seeks to ensure that public safety is the paramount consideration when decisions are made about not criminally responsible and unfit accused. Second, it creates a new high-risk, not criminally responsible accused designation. And third, it enhances victim safety and victim involvement in the mental disorder regime. Now, with respect to the role of public safety in the Review Board decision-making process, C-54 clarifies that public safety is the paramount consideration in the decision-making process. As I just mentioned, the current approach is to balance four factors, of which public safety is one of the four factors. To ensure consistent application across the country, our bill would codify the meaning of significant threat to the public, to the safety of the public, consistent with the way it was interpreted by the Supreme Court of Canada. It would clarify that the Review Board can continue to impose restrictions on a not criminally responsible accused who risks committing further criminal acts, even though they do not pose a threat of violence per se. For example, if they are concerned about a not criminally responsible accused committing thefts or break-ins, they would be able to maintain jurisdiction over them and impose the necessary and appropriate conditions. Now, Mr. Speaker, I'd like to turn to one of the key features of Bill C-54. The bill proposes a new scheme which would permit the courts to designate certain non-criminally responsible accused as high risk. This high-risk accused designation would ensure that a person so designated is held in custody and cannot be considered for release by the review board until the designation is revoked by the court. A person found by the court to be a high-risk accused would not be entitled to unescorted passes into the community. Mr. Speaker, I've had the opportunity to discuss a number of these issues with my provincial and territorial counterparts. In fact, a number of them wrote to me about concerns they've had, including the need to ensure that public safety is the paramount consideration in the decision-making process. I can confirm that my provincial and territorial counterparts support the idea of expressly making public safety paramount. Closing, Mr. Speaker, I would like to say that I think the bill effectively balances the right of the public to be adequately protected when mentally disordered accused persons pose a danger to society with the rights of unfit and not criminally responsible accused to be treated fairly and appropriately. And I urge all members to support this important piece of legislation, Mr. Speaker.
I think that Maître Hébert touches on something very relevant here. Are we talking about prisoners or patients? Clearly, these are patients. These are people who have been recognized as having mental illness, mental disorders that are serious. So if we think the verdict is a bad one, there's a solution for that. You're a lawyer like I am, Mr. Speaker. In a context like that, that means that there can be an appeal if we're not happy with the verdict. If the facts are correct, I think that Mr. Turcotte's case is being appealed. If we think that the diagnosis and the judge's decision, according to the balance of probability under Section 16.2, if this has been well established, the Court of Appeal will uphold the decision by the judge, or it will reverse this and say, no, you cannot use that defense. You don't have serious mental illness, so in this context, you cannot be found not criminally responsible. But that's not where we're at right now. That was the case. So this person has a serious mental illness, is taken in by the state, and another system comes into play. And that's what C-54 tries to do, that the percentage of people found not criminally responsible for crime, regardless of what the Boivinus of this world may think, who think there are hundreds out there, there aren't. Yes, it has increased over the years, but we have to remember that what's not being said here, that before 1991, if memory serves me, when there was an amendment, it used to be called not guilty because of insanity. Now it's because of mental disorders. When there was that amendment in 1991 to the criminal code, it was then summary offenses were added as well. And that brought about a whole new series of cases that didn't used to be covered. So of course it had an impact on statistics. But given the government's response here, we're talking about a tiny minority of cases of criminals found not criminally responsible. This is not something that should be looked at lightly to inflame the population. On the contrary, we must explain what's really going on, because this is an area where no one here knows much about, unless there's a psychiatrist who was elected in 2011, and I don't think so. Ask yourself this: would this bill mean that somebody like Dr. Turcotte is high risk? When I look at the definitions included in the C-54 file, absolutely not. He does not meet the criteria at all. But if you look at it, public safety was and is, and the courts have repeated it, is not the most important criteria. Perhaps he's right, the minister's right to say he's made this the top priority, but the courts were using it that way. Do you seriously believe, Mr. Speaker, that a court or a commission that is considering releasing someone who was deemed not criminally responsible and who committed a horrible crime are going to release that person without looking at public safety? Do they think these people are idiots? So for all these considerations, we will support the bill in second reading, but this will require in-depth examination. We shouldn't re-victimize people, because the Conservatives can't say that they're not victims too. If you're that sick, there's nothing much to do except to try to cure them. Thank you, Mr. Speaker.
C-54 does contain some measures that are reasonable and worthy of support, such as keeping victims' families better informed and prohibiting perpetrators from contacting victims after their release. NCR accused are neither found guilty nor innocent. As the Supreme Court explains, this regime supplements the traditional guilt-innocence dichotomy of the criminal law with a new alternative for NCR accused, an alternative of assessment to determine whether the person poses a continuing threat to society, coupled with an emphasis on providing opportunities to receive appropriate treatment. According to researchers from McGill University and the Université de Québec at Trois-Rivières, 90% of people with mental illness are nonviolent. Moreover, a report prepared for the Department of Justice shows that in 2004, the last year's study, only 0.18% of all criminal cases resulted in the finding that the accused was either NCR or unfit to stand trial for reasons of mental incapacity. Finally, a Canadian study from 2003 puts the recidivism rate for people who've been found NCR, treated and released at just 7.5%. By contrast, those who are not NCR and serve in federal prisons have a reconviction rate of over 40%. I realize that I'm using many numbers here and do not want there to be any confusion. This bill is dealing with less than 10% of a population that is already less than 1% of all those criminally accused in Canada. C-54 would allow certain NCR accused to be designated high risk not by mental health experts but by criminal courts. This designation would devolve subsequent decision-making authority regarding the accused from specialized review boards to criminal courts once again, despite the fact that general criminal courts lack the requisite expertise to make determinations about the risks posed by a person with mental illness. The high-risk designation, Mr. Speaker, combined with tripling the time period between reviews from 1 year to 3, may cause NCR inmates to remain in custody long after successful treatment. Such an outcome would be unacceptable, given that, as the Supreme Court has stressed, NCR accused have not been convicted of a crime. Indeed, as the Court has stated, and I quote, "The NCR accused is to be treated with the utmost dignity and afforded the utmost liberty compatible with his or her situation. The NCR accused is not to be punished, nor is the NCR accused to languish in custody," unquote. Accordingly, C-54 could lead to charter claims both with respect to the Section 7 right to life, liberty and security of the person, the Section 9 guarantee that everyone has the right to be arbitrarily detained or imprisoned, and we could see Section 15 challenges as there is a prohibition against discrimination on the basis of mental disability. Detaining more NCR accused for longer periods of time gives rise to the very practical problem of where these individuals will reside while in treatment. For this reason, I have asked the government for details about the capacity of the mental health institutions in which NCR accused are placed and about any plans to increase that capacity, as well as any analysis that has been performed of C-54's potential consequences in this regard. It is by no means clear that our system is, at present, capable of dealing with greater numbers of NCR accused institutionalized for longer periods of time, and we risk complicating their recovery by straining the resources of the institutions and individuals that are treated there. That potential strain and resulting decrease in the effectiveness of such institutions, combined with the possibility that NCR accused could be detained for years even after successful treatment, might mean that mentally ill accused will be less likely to plead NCR as a result of this bill. We would therefore find ourselves with even more mentally ill people in our prison system, and I'm sure that I do not have to remind members of the tragic consequences of housing people with mental disorders in prisons rather than medical facilities. There are consequences for the inmates, as was demonstrated by the heart-wrenching videos of Ashley Smith, and there are consequences for public safety, that which the government says is their primary concern that underpins this bill. When mentally ill people are returned untreated into society after serving a prison sentence, they pose a far greater danger than NCR accused who have been treated by medical professionals and evaluated by experts.